August 23, 2013, Ochawi Carpenters was detained and taken to Guantanamo Bay following his post in the Washington Post. Carpenters is being accused of a possible threat to overthrowing the government. His post in the Washington Post read this:
"Once America gets taken over by North Korea, it will realize its inferiority."
Carpenters was not given the right to a lawyer because he was considered a threat to the U.S. safety. Said post, police were granted a search warrant and found 78 threatening letters as to how he hoped to rule with North Korea over America. These letters included his hope to return to North Korea to fight for their army, plan to investigate the government, and share information deemed necessary. The Washington Post released a decision on August 24th, apologizing for this publication, saying that they were intending to share one American's opinion. Without family living in America, Carpenter's previous lawyer, Michelle Blunty, decided to file a case in the Western District of Washington District Court. And for more information on this subject, I sat down with Michelle Blunty to see how she viewed Carpenter's right to freedom. Michelle, how do you see this case is unfolding? How do you think America is handling the situation?
Carpenters was wrongly given punishment for something that was un-American. To prove this point, I cite past Supreme Court cases that guaranteed people the right to a fair trial and or freedom of speech. The Hamdi versus Rumsfeld case set up how, due to due process of law, Americans are given the right to a lawyer even if they are dangerous towards the United States. Boumediene versus Bush also sided with potential terrorists as it ruled that the men suspected for an attack on the U.S. Embassy in Bosnia still had to be given habeas corpus, and that the Military Commissions Act was unconstitutional. Hamdi versus Rumsfeld also showed how enemy combatants are still guaranteed habeas corpus.
And considering how Carpenters got 15 years in Guantanamo Bay and then deportation back to North Korea, what do you think would be the fair punishment for his actions?
Carpenters is nothing but a nationalist. He wants his country to be strong and feels connected to the 24 million plus that live back in home for him. With that said, our First Amendment guarantees anyone the right to say and speak their mind. The U.S. government has opened up his personal life, taken control of what is legally his, and has accused him of some maltreatment. To answer your questions, Tom, not only should he be instantly released and free of all charges, the government should pay all dues, including medical mental health bills.
Thank you very much for your time.
Thank you.
It seems as though the government has had many rulings in which it exercises a right to essentially do what it wants when the people are in danger. Ex parte Quirin gave the authority to the United States government to have power during its international wars. Korematsu versus United States under the Stone Court set the precedent for giving the federal government power to control threats against the American society. The law that called for Japanese camps was called the Civilian Exclusion Order No. 34. To protect the people, America has demonstrated how it will take safety over liberty.
It's Tyrone Biggums, and I'm a history tour guide here at the U.S. Appellate Courts. Dating back to Thomas Jefferson, all Americans are given the right to life, liberty, and the pursuit of happiness. This right should not be infringed upon, and the court's ruling to support people who have even put the country in danger is apparent in the previous cases. Michelle Blunty, representing Carpenters, argued that the First Amendment to the Constitution guarantees Congress shall make no law abridging the freedom of speech or of the press. And she said limiting one's freedom of expression about their home country is unjust, immoral, and not American. Ex parte Merriman displayed how it was illegal for rights of Americans to be paused even during the time of war. Also, During Ex parte Milligan, the Supreme Court ruled that the military does not overpower the federal government, and essentially, martial law does not dominate.
To hear the flip side, I sat down with lawyer Mark Dennenberg, chief lawyer of the federal government. Mr. Dennenberg, why do you think that carpenters' rights should be limited?
Carpenter is a dangerous person. He threatens the security and integrity of the American people and the way of life. Throughout American history, we didn't fight our wars and then release our opponents amidst chaos. Here, we aren't going to capture a man that provides an imminent threat to the well-being of our people, only to say that he's allowed to speak and therefore threat the nation as a whole. Throughout US law, the legislative branch has defended the safety of the people, and this applies against carpenters here as well. Both the Espionage Act of 1917 as well as the Sedition Act of 1914 work to keep the possible threats out of the country, and both can be applied here. These and more are the justifications why he's a threat to the American people.
And what do you see as the essential question of the case?
The essential question of the case was whether a native of a country that is at war with the United States has full right to allude to a plan of how their home country will destroy the USA. If threatening other Americans, we won't let someone threaten us and then execute just because they have freedom of speech. A threat is a threat, and no one can't do something that will lead to hurting of the innocent people.
From this interview, I concluded that Mr. Dennenberg would disagree with Benjamin Franklin when he said, "They who can give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety." This court case dealt with the rights of a person who is an enemy of the United States at war. Also considered was the use of freedom of speech with a private newspaper as opposed to a public location. This case quickly developed as America fought North Korea in the war of the summer of 2013. This court case was riveting as Blunty fought Dennenberg for freedom of speech versus safety to the American people. In a 5-4 decision, the Supreme Court ruled against Carpenters. Chief Justice John Roberts Jr. cited the Espionage Act, specifically the part that said, "Whoever, when the United States is at war, shall intend to interfere with the operation or success of the military or naval forces of the United States, or to promote the success of its enemies, shall be at once dismissed from the service." This court case set tone for many questions to the rights of the federal government to limit threats to America during times of war. All in all, the Supreme Court ruled safety first.